This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. No case has galvanized the American public along racial lines as much as the O.J. Simpson murder trial. The intense scrutiny the attorneys, the judge, and the jury received by the media will have far-reaching consequences way beyond this year. Today we'll look at the difficulty in trying these types of high-profile cases with Judge Frederick Berman, acting Supreme Court Justice in New York County and adjunct professor of law at New York Law School, and James LaRosa, a noted criminal defense attorney who's tried numerous high-profile cases. Hello, Judge Berman. Hello, Jim.
Hello, Alan.
Judge Berman, what did you think of the verdict?
I was surprised.
Shocked?
Not shocked, but I was shocked at the shortness of the deliberation.
Right.
And once I heard how short that deliberation was being, I think the verdict was obvious, because there was no way that jury was going to convict after only 3 hours of deliberation, in my judgment.
Jim?
I thought the same thing. The day before, I told the Daily News, and they reported it, that I thought the deliberation, being as short as it was, could only be an acquittal.
However, there were different viewpoints. I've heard many commentators and many well-known attorneys around the country said, since the jury did not look at O.J. Simpson when they walked in that first day, and the part that they read back was for the prosecution and not a cross-examination, that many people came up with different views.
I know that.
But you know, Alan, I have found in my own experience of trying cases, when the jury walks into the room and often refuses to look at the defendant, that can very, very well mean an acquittal, and I've seen that happen many times, so that you really can't judge on the basis of how they look at the jury when they come back with a verdict.
Jim, were you surprised by
They're either one way or the other. I agree with the judge. Often they'll come in and smile at you and you know you're okay. Other times they never even look over at you and a chill goes through you until you find out they've acquitted your client.
Were you surprised by the acquittal?
No, I was not. I thought it was going to be an acquittal right through the trial.
Why?
A number of reasons. One, the ineptness of the prosecution. Yet, you know, nobody's talked about the concept that a prosecutor put on a key witness here, knowing that witness had perjured himself.
However, they said they had to put it on because he found the glove.
Well, let me tell you something. I think that there are disciplinary rules that prohibit any lawyer from putting on a witness who knowingly is perjuring himself. And why nothing's occurred with respect to that is beyond me. I think something should be done about this. They didn't have to put that witness on. They could have told that court that they believed that witness wasn't telling the truth in terms of the racial epithets. That witness was perjured itself, and the district attorney of Los Angeles County knew it and willingly did it. They threw that case away.
And you know, Jim, there's another factor too that I'm concerned about, because of the fact that you had a police officer who was such a rogue cop.
Mark Furman.
Mark Furman. I have found in recent years, and it's going to be more and more, that jurors are more and more distrustful of police testimony. And when you have, for example, a drug case where you have an undercover officer as the sole witness testifying against the seller, often the jury is very dubious about returning a guilty verdict, even though it appears that the people may have proven guilt beyond a reasonable doubt.
Judge, I know you watched it on TV. Were you surprised on the verdict?
No, I wasn't surprised. I thought it might be a hung jury, but I certainly wasn't surprised at the verdict.
Tell me why.
Well, because, again, I felt that as I mentioned earlier, as soon as I heard the length of the deliberations...
No, I'm talking about during the trial, before that.
Well, you know, the evidence, there's no question, Jim is right, the evidence in this case was really flawed in so many respects. The defense, whether you agree with their tactics or not, knocked holes into the people's case, and it certainly gave the jury every opportunity to find a reasonable doubt, and many reasonable doubts, which would have resulted in the verdict that it did.
And is that what you felt while you were watching it on TV, when you heard the summations?
Well, you know, One thing I've learned, Alan, is that you never can judge a case unless you're actually in the courtroom, watching the demeanor of the witnesses and being there and getting that feel of what's going on. You can't judge by what you see on TV, and you certainly can't judge what you read in a newspaper on the basis of some reporter's interpretation of what took place.
Jim, what do you think of Judge Ito? How he handled the media, how he handled the attorneys, and the evidence?
I thought he was terrible. I think any New York judge would have tried that case in 3 months. Maybe it would have resulted in the same verdict or not, but I thought he lost control of the courtroom. I think it's ridiculous to have a sequestered jury and work 3 or 4 hours a day. I tried a major sequestered jury case in this town about 17 or 18 years ago, Anthony Scotto.
Yes, of course.
And when Judge Stewart sequestered that jury, we worked 6 days, and at the end of the trial, we worked 7 days to finish it up. Judge Ito had no regard for the jury.
What about his rulings on the law?
Well, I thought his rulings on what you could introduce against Furman were ridiculous. Here's Furman, a key witness, who admits in a taped interview that he thinks nothing about setting up defendants by putting phony evidence into a case, and that jury wasn't permitted to hear that. I think it's ridiculous.
What about
But remember, though, Jim, he did give a ruling that was somewhat favorable to the defense, and the prosecution immediately went to the higher court, and they said, no, you can't do it.
That's true.
Even that procedure, wasn't that unusual?
Sure, absolutely. I've never seen that done in the middle of a trial
Yes.
in our New York courts.
Well, I think Los Angeles has a provision that permits it. But the bottom line is, I'm not suggesting that he was one way or the other in terms of his rulings. I just think they were sloppy both ways, both for the prosecution and for the defendant.
Judge Berman, you've been sitting as a criminal court judge now, trying felony cases for over 2 decades.
Right.
What do you think of Judge Ito's handling
Well,
of the case?
I'll be a little kinder than Jim. I thought that he had an impossible job. I think he made some mistakes. I think he leaned over backwards to try to be courteous to the lawyers, give them time to argue, gave them too much time, and they took advantage of him. And as a result, he lost control of that courtroom.
By losing control, was justice put in jeopardy?
I think the worst part of the trial is the fact that the public's perception of the criminal justice system has been very sadly tarnished. And those of us in the business, of course, know that what took place in Los Angeles is totally atypical of a way a trial is conducted. Wouldn't you agree, Jim?
I agree. I've worked out there. It's a different world. Judge Berman's being kind. If Judge Berman was presiding in that case, it would have taken 3 months. Everyone would have had their say. All of the witnesses would have been properly cross-examined, and the case would have been over. There's no reason for this to be a year. It's a murder case. There was no reason for this to be a year. There was no reason for Menendez to be as long as it is. I think it's something to do with the warm weather in California.
What do you think of Judge Ito's rulings?
Well, I thought generally on his evidentiary rulings, I agreed with most of them. You know, obviously, judges can disagree, as we know from our appellate courts, but I thought for the most part his evidentiary rulings were pretty much along the lines that I would have ruled as well.
Marcia Clark, what's your comments?
I thought she was very weak. And again, to go back to the Furman concept, that glove wasn't essential to prosecute O.J. Simpson. It wasn't essential at all. They could have left that glove out, and they still had mountains of testimony. To bring in the racial aspect of Mark Furman into that case threw the case out the window.
What's your comment on, I just heard one of the jurors comment again, the glove did not fit. What about that test?
I thought that was a wild piece of wild testimony that the prosecutors attempted to do. You never try and do something in front of a jury unless you're sure that it's going to work. You don't ask a question unless you know the answer. You don't have someone try on a glove unless you're sure it fits.
What did you think of Christopher Darden, the prosecutor?
I thought he did a fairly decent job. I thought his summation was very good.
And you know, I thought that Chris Darden was in the most difficult spot of all of the lawyers, because after all, he is a member, he's an African American who was charged with the responsibility of prosecuting a very popular celebrity African American, and that had to be a very difficult task for him, and I suspect that from his point of view, he's going to have problems relating to a lot of other African Americans who disagreed with his role in that case. And I read just recently that he's decided to give up the practice of law, or at least leave the DA's office, and I think he's going to write a book.
Well, that's quite surprising. However, I remember seeing him after the verdict. He started almost breaking down and crying during before the cameras.
Well, this was a very emotional trial. You know, a lot of people watching it on TV broke down and cried on both sides. People who heard the verdict, they cried with joy. And there were other people who heard the verdict and they cried in despair.
All I could say is it reminded me that 10 minutes between 1 o'clock and 1:10, in our office, the phones literally stopped. It was like the time, that movie when I was a kid, the time the world stood still.
Well, AT&T, I understand, lost a tremendous amount of money during that period because nobody was on the phone.
Marcia Clark, give me your comments.
Well, I was disappointed with Marcia Clark in the sense that I didn't think she had organized her witnesses as well as she should have and had prepared the evidence as well as she should have. However, I thought her summations at the end were the high point of her presentation, and I thought she did a very good job.
Attorneys for the defense, give me your comments.
I thought Johnny Cochran did a marvelous job in summation. I thought his preacher-like presentation to the jury was appropriate under the circumstances. I think I was disappointed in Mr. Shapiro. I was disappointed in the way he ended, certainly, by criticizing his fellow lawyers and how they handled it.
I believe he said that Shapiro's summation was...
Cochran's summation.
Yes, Cochran's summation was from the bottom of the deck, the racial card.
That's ridiculous. That's ridiculous. Of course you appeal to the jury and whoever they are. Everybody should do that. You should appeal to their emotions. You should appeal to their sympathies, to their bias, and to the evidence or the lack of evidence. Of course you do those kind of things. We all do them. Any good seasoned lawyer does them.
But Jim, I think the reference to Hitler and the Holocaust, in that reference, I think he overstepped the bounds.
I agree with you, Judge. I agree with you completely. I think that was just a step too much. Other than that, though, I think he did a terrific job.
Can sometimes you say something like that and it has the reverse effect on a jury?
It could, sure. You can antagonize a jury sometimes if you say the wrong thing. I think lawyers in summation will probably agree that if they make a major mistake in a summation, that's the last thing that the jury hears from the lawyers, and that can come back to haunt them.
People are always interested in money, Jim. How much is an offense like this for O.J. Simpson, who had the dream team? How much would something like that normally cost?
A lot of money.
I understand a lot of money.
Millions. If we're talking about lawyers, if we're talking about first-rate lawyers,
which these were,
in the North,
F. Lee Bailey,
in the Northeast, and charging patterns, you would be well into the millions of dollars.
Well, the prosecution said their case cost in excess of $5 million.
I'm not surprised.
I wouldn't be surprised if his defense was more than that. And as a matter of fact, I thought it was interesting in his interview that he gave to the New York Times, he dispelled the idea that he was wiped out financially because he made mention, I still have my Mercedes and another car.
His Bentley?
Still have my home out there.
In Brentwood?
And I have a home in New York, so he wanted the world to know that he's not wiped out yet.
I thought that was poorly handled, that interview at the end. There was a group of us ready to critique him on CBS that night before the notification came in.
That he was not going to be interviewed by Brokaw.
That he was not going to do it. I mean, the concept of him agreeing to do it and then backing out at the last minute, I think, was terrible for his public image.
However, you do civil work as well. I know some of your firms. Well, what would you advise him if you were his attorney?
I would have never permitted him to agree in the first place. So something fell through the crack.
I think it was a major PR mistake on his part. There's no question about that.
I agree.
Is everybody in this case going to write books and become famous, or if they're not already?
Oh, I think they're going to see a lot of books.
If you were to try the case for O.J. Simpson, would you have done anything differently than Cochran?
Well, the only criticism I have is at the beginning it seemed like they didn't have all of their ducks in order. Like they didn't know where they were going initially. One or two theories changed throughout. Other than that, I think he did a very fine job.
Was the key part of the case, Judge, as far as when you were watching it, when they brought in the witness who had these 10 years of taped conversations with Mark Furman?
Well, that certainly was a key point. I think the thing that probably most people have commented on was that glove experiment, which failed.
The glove didn't fit.
More people have talked about that mistake than anything else that took place in the trial. And it really wasn't of that significance, I thought. But Jim was absolutely right. You never try and experiment on your own witness unless you know how it's going to come out, and you don't ask a question unless you know what the answer is going to be.
And Jim, what was your comment when Conklin would always say continuously in a summation, if it doesn't fit, you must
acquit.
And with that, we're going to go to a break. You're watching Lawline. We're talking O.J. Simpson. I'm Alan Schnorman, your host. Stay with us. Hello, I'm Alan Schnorman, the host of Lawline, and I want to give you some important information about your legal rights. If you were seriously injured in an automobile, a fall down, or construction accident, you may be entitled to a substantial money award for your pain and suffering. It is important to speak to a knowledgeable attorney in that field. At my firm, Solomon & Schnorman, our practice is limited to personal injury law. We fight for the rights of accident victims. Don't try to evaluate the case yourself. If you have any questions about your accident, call us at 1-800-LAWLINE. If you're too injured to come to our office, we will come to you. The consultation is free, and we only get paid when your case is settled or won. Remember, the insurance companies have lawyers protecting their interests, and so should you. Hello, I'm Alan Schnorman. You're watching Lawline. We're talking about O.J. Simpson and the verdict. Do you agree with the verdict? With us with Judge Frederick Berman of the Supreme Court, New York County, Acting Supreme, and James LaRosa, a noted defense attorney. Gentlemen, the question we have is, we know where the verdict was. How is this going to affect the next criminal trials? How is this going to affect your criminal trials now that you're going to have jurors who've been watching this for month after month who may or may not agree with the verdict?
Well, it started to affect them already. The judge in the Menendez case turned down cameras. You notice the case that's being tried in Houston, I forgot the name of the singer, the famous Hispanic singer.
Yes.
The judge excluded
Murder
cameras.
trial.
I think you're going to see more and more of that. I think cameras don't belong in courtrooms. And I think that this has been a great learning experience.
Judge Berman, do you want cameras in your courtroom?
Well, I've had them in my courtroom on occasions, and I think in certain instances it's desirable, but certainly not in a case where you have a defendant who's a nationally known figure, respected by many, and where the lines are immediately drawn on the part of the public, whether they like him or don't like him. I think to have cameras in that situation was a terrible mistake. And incidentally, Jim is right. You know, in the federal court, we just had a case in New York, the terrorists who were going to blow up the UN and the Lincoln Tunnel. That case was almost as long as the O.J. case. There were no cameras in the courts allowed in the federal courts, and you did not see the kind of circus and spectacle in that case. Very few articles were written, only really the New York Times did an occasional article, but that's the way it should be conducted.
James, what's your opinion about cameras in the courtroom?
I think they shouldn't be.
Why?
I just don't think it works.
Why?
Because you create a circus-like atmosphere.
What's wrong with the public going into the courtroom, seeing the attorneys at work, seeing the judge, and hearing the same thing the jury hears?
There's nothing wrong with that, but once you bring the cameras in, it becomes circus-like. You remember the Steinberg case not too many years ago
Yes,
in New
I
York?
do.
The same thing happened. I mean, every one of the channels started to publicly watch it.
That's where the attorney used to give press conferences after every day's...
Exactly, and a lot of us started to be color commentators. I did NBC for a week. I sat there as a color commentator. Trials don't need color commentators. They don't need people like me telling them what's right and what's wrong, and jurors going home at night and saying, this is what LaRosa said or this is what Smith said.
Judge, doesn't the public have a right on any case to see what's going on in the court system?
Oh, they sure do, and of course they're welcome to come down to court anytime and enter the courtroom. The whole question of cameras in the courtroom is a very delicate one at this point, and I think you're going to find that many of the states that permit cameras in the courtroom are going to revisit that issue, and the state legislatures, in many instances, are going to revoke cameras in the courtroom.
However, Judge, we talk about public in the courtroom. Most of the, and especially in high-profile cases, the public can't even get into the courtroom. There might be lines around the block and between different print media reporters and family. There's really no room for it.
Well, you're balancing a couple of constitutional rights. That is, an open courtroom versus a defendant's right to get a fair trial. And if you have a circus atmosphere, you're not going to get a fair trial.
But didn't the public learn so much by watching a trial almost from beginning to end? I mean, this trial was on CNN every day. It was on court TV continuously, almost on a daily basis. Every news, TV program, as well as radio program had excerpts. Doesn't that help our system?
Well, it should, and in theory, it should certainly do that. But the problem is this case, where many people were seeing a trial for the first time, I think diminished their respect for the criminal justice system, and I think that's a very sad commentary.
Is that because of the verdict or something else?
A combination of many things. I think the way the lawyers acted, the length of the trial, all of the distractions that took place, and the verdict to a certain extent as well.
James, do you think that it'll have any effect on juries?
Okay.
Your future juries, the O.J. Simpson matter, and how?
Oh, sure it is. I think the judge is right that jurors are going to start to mistrust, as they have in the past on many occasions, law enforcement officers. After Watergate, there was a whole period of about 18 months or 2 years where every federal agent that took the stand was really suspect. I think every police officer is going to be suspect right now. And I think it's because of what came out of this. This trial set back the legal profession 5 or 6 years.
And you know, not only that, Jim, but I heard that when Robert Shapiro went out to eat after the verdict, a day or two later, he was in a restaurant and people started to boo him as he walked in. Some people started to throw crumbs of bread or pieces of bread at him.
What does a not guilty verdict in O.J. Simpson really say? What does it say?
It says that the people didn't prove the case.
I understand that.
And based upon, you know, when I look at the evidence and when I look at the way that case could have been presented, I'm a former prosecutor too, by a skilled prosecutor, this case wouldn't have been an issue. I don't care what the jury made up
After the
was.
verdict, the district attorney of L.A. County, when interviewed, and when they asked him, well, will you now look for someone else? He says, no, we had the killer.
Well, the district attorney probably had the killer, and the district attorney probably had the evidence, but they booted it all over L.A. County. All over L.A. County. We're forgetting a lot of things. Do you remember the socks that were found in O.J.'s bedroom?
Yes.
With the blood stains that the analysis proved to be hers?
Yes.
Do you remember the pictures that were taken initially where there were no socks lying on the ground?
I saw that in the summation of Johnny Cochran.
Now, I don't understand how that could be, and I'm not a layman.
It was never explained, even on rebuttal.
Matter of fact, I do know how those things happen, okay?
How did it happen?
They happen because some policeman who's convinced that man did it tries to tilt the deck a little bit.
Are you saying that perhaps that happened here?
I don't think it's a perhaps. It's clear to me that some of those things happen. And someone like Furman, who's completely untrustworthy, shouldn't be permitted to be...
Planting evidence, isn't that a crime?
Of course.
Absolutely.
Forget planting evidence. Did Furman perjure himself?
No question.
And what happened? Did you see an indictment the next day?
The federal government has said they're looking into it. The
What
Justice
federal
Department.
government? What's the matter with the LA district attorney? He committed perjury in that trial. In that trial. And it's been proven now by his own voice. Why hasn't he been indicted?
I have another problem with the DA in L.A. County. Garcia constantly throughout the trial was holding press conferences and going on TV. That is ethically improper, actually. You know, take New York, for example. Bob Morgenthau, the DA of New York County, holds a press conference when he announces an indictment. And that's the last you see of Bob Morgenthau until after the verdict is reached. And that's the way a prosecutor should operate.
Well, Bob Morgenthau was not trying to get a higher office anywhere. I'm not running for anything else.
But isn't that unfortunate that because one might be ambitious to run for higher office, that they're violating what it clearly matters that go to the very ethics of the profession?
A prosecutor can't use his office to achieve higher office. If he does, he's a failure.
What do you think is going to happen in your courtroom? What is happening now in your courtroom with jurors who've been watching this, who may or may not agree with the verdict, who may not agree with the system? How are you handling it?
Well, it's interesting because earlier this week I was charging a jury, and I was about to charge a jury when the two-defendant robbery case, when the defense lawyer stood up and moved for a mistrial on the basis that his client felt that because of the O.J. situation that he therefore could not get a fair trial and a fair verdict from this jury. I thought that was very interesting. Yes.
Interesting.
Obviously, we denied that.
Oh, okay. Although it may or may not be true.
Well, but there's no way of proving that. And of course,
Would you have to poll the jury?
No, absolutely did not do that. But, you know, if you follow that argument to its logical conclusion, you won't have any trials anymore in the state and in the federal system. So there'd be no way that that could be a serious argument. But I guess the attorney felt he wanted to make the record, and maybe an appellate court might find that interesting, but I doubt it.
Your comments on the whole situation here.
We'll overcome O.J. like we've overcome so many other things in the past. It might take another year or two for us to forget the trial, but we'll overcome it.
Judge, how would you have improved the situation if you could?
Oh, there are so many ways. We don't have time.
Of course, this is Monday morning quarterbacking.
Yeah. Firstly, in retrospect, of course, there should not have been cameras on that case. Secondly, that jury never should have been sequestered. You had a jury that were actually in prison for all that time, and at the end, the reason probably why they deliberated for only 3 hours was they were anxious to get out of there and go home.
That's what they said. They felt they were in prison. But how did cameras in the courtroom have an effect on the verdict?
I just think that cameras in the courtroom cause the American people to develop opinions about the case. It caused the attorneys to act out on the stage of the courtroom. I mean, this is not entertainment. This is supposed to be a serious matter. And I think the lawyers on both sides saw this in a way. They had become celebrities themselves because of this case and because of the cameras.
James, what held this fascination the public had with this case? How do you see it?
It was a great case. He was a noted personality. He's a handsome guy, a beautiful woman. Sex, other people involved. I mean, it had all of the parameters of a great case.
But even before it started, I read one newspaper article that they estimated 95 million people saw the verdict, and over 40 million people saw in the beginning, when his Bronco, the famous white Bronco, was on the streets traveling. I mean, it just held everybody spellbound. There must have been something.
It fascinated America. There's no. Forget America. I was in Italy for 2 weeks in the beginning of September. Every night it was on TV. The Italians were watching it.
But the killing was so violent. I read something that he actually, when the killer cut part of not only the arteries, but part of the spinal cord. I mean...
Now, these were two very brutal murders. There's no question about it.
In summation, quickly?
I think that law enforcement has to come away with a lesson from this. They've got to play it straight.
Judge?
I think there are going to be major changes in the judicial system in terms of how we pick juries, how we conduct trials, what restraints, if any, we put on lawyers in terms of giving outside press conferences outside of the court on matters that are not introduced into evidence.
Judge Frederick Berman, Acting Supreme Court Justice, New York County. James LaRosa, thank you both very much for appearing on Lawline. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.